Hi everybody and welcome to our Legal Eagle webinar. This afternoon we're going to be chatting to Janusz Luterek from Hahn & Associates, and we've got some exciting information to talk about, especially in line of all the recent press activity regarding and tampering with labeling. Before we get into the meat of the presentation, I want to just introduce Janusz. I'm sure for many of you he is a well-known, but for us he's a friend, and so we just want to give you a bit of background. He's both an engineer and an attorney, and he is a partner at Hahn & Hahn. Has done extensive work in patent law, as well as work both with retailers and supplier to retailers, and is definitely a food law expert in South Africa. Janusz, thank you for joining us today, and we're looking forward to your presentation.
Thank you very much, Linda. It's a pleasure to be here and to discuss this important topic, as you say, especially in the light of the two very recent scandals in which the whole issue of durability dating has been brought to the fore.
Absolutely, Janusz. I think there's a couple of things that I wanted to kind of lay a foundation as far as the presentation is concerned. Some questions that we would like you to answer. The first is, there's a lot of confusion between best before, sell by, use by. So I'm hoping that you'll be able to give us some clarity with regards to what the law says about date markings. The second thing is the whole issue of tampering of date labels. Obviously, we'll need to talk about that, changing labels or changing the dates associated with products, and then any advice that you can give to suppliers of products going into the consumer marketplace. So I'm going to hand it over to you, and I'll ask you some questions as we go through.
Okay, great. Well, I'm going to put on my presentation now, in which I will cover the definitions, how the law sees the various durability dating issues, and address a number of the questions that you've raised.
Great, thanks, Janusz. Right, so Janusz, we've got your presentation up, so if you'd like to start and go through it, that would be great.
Sure, thanks. So as you'll see from the title, I talk about durability dating, tampering, and of course the liability associated therewith. So I think firstly we need to understand the legal position around durability dating in South Africa. And firstly, we have the Foodstuffs, Cosmetics and Disinfectants Act, the so-called FCD Act. And under the FCD Act, we have the Food Labeling Regulation, so-called R146. And in that regulation, we have definitions and we have prohibitions relating to durability. Section 5 of the FCD Act also has a prohibition with a criminal consequence relating to false descriptions, which includes durability dating. We have the Agricultural Product Standards Act, which falls under the Department of Agriculture, and there some of the regulations require use-by dates on products. Other regulations require best before dates, for example, eggs, but they don't deal so much with the consequences of tampering with those dates. And then, of course, we have the Consumer Protection Act, which is the act made to protect consumers in general, and under that act, we have a provision relating to trade descriptions and honest labeling, and there you can be fined or prosecuted for providing false information. We have Section 61, which provides for civil liability for any harm caused by any product, for example, by expired foods. And then we have Section 110. Now, Section 110 was the one that was recently relied on by the National Consumer Commission when they raided the South Baycoast premises in Bloemfontein. And in terms of Section 110, it's criminal to tamper with any trade description, which would include any durability date. The Consumer Protection Act is the act that provides for the biggest fines and the highest level of liability. So, under R146, the food labeling regulations, we have a definition of date of minimum durability, otherwise known as the best before date or the best before end date. And quite simply, this means that the date which signifies the end of the period under any stated storage conditions during which the product will remain fully marketable and will retain any specific qualities for which tacit or express claims have been made. However, beyond that date, the food may still be perfectly satisfactory. So, firstly, you can see that it indicates food quality, not food safety. The food should still be fine after this date, and in fact, it could be fine for a long time, in fact, a very, very long time. I recently ate a jar of sauce, which came from Ina Parman's kitchen, which was, by the way, bought well before the best before date, but I found it in my pantry, dated November 2015. I cooked it with my sauce, very nice, ate it, still here to do the presentation to you. So clearly, the best before date bear on the food safety of various products. The color was a bit off, the taste was fine.
But now, Janusz, I have to interrupt you. Did you do that in preparation for this presentation just to prove a point?
No, not at all. I eat whatever's in my pantry as long as it looks like it hasn't gone off. I also don't eat something that's been opened that's been in my pantry for any period of time. But things like dried goods and canned goods, they have a long shelf life.
Yes, absolutely.
Despite the best before date. And, you know, there's a lot of debate around the best before date, because maybe we can talk about that here briefly, but best before date can lead to a large amount of food wastage if people misunderstand what it means. Because if you throw away everything in your pantry that's only reached its best before date, you're throwing away a lot of very good, safe and good quality food.
Absolutely. And I think we've seen your recent tweets in that regard. You know, we've posted some articles about it because, you know, food waste seems to be an international concern and something that does need to be addressed, and all the factors that are contributing to food waste, you know, I think definitely need to be re-looked at.
Yes, I must also add that it doesn't really help when there are television programs in which it's represented that a company that's got food after its best before date is somehow committing a criminal offense, because they're not. It's not a criminal offense to have food stuff after the best before date. As you will see further in the presentation, the criminal offense is to change that date.
Absolutely. And I mean, I think there's even a retailer in the Western Cape that only sells product that has exceeded its best before date. And as you say, it's you know, from a quality perspective, there are warnings related to the quality may have, you know, it may be slightly off, but at the end of the day, it's still perfectly marketable. It's still perfectly eatable at the end of the day.
Well, typically the issues of it might the flavor might not be quite as good, the color might have changed slightly, but it would still be perfectly safe to consume.
Absolutely. Okay, so continue.
So the next date that's in the regulation R146 is the sell by date or display until date, which means the last date of offer for sale to the consumer, after which there remains a reasonable storage period at home. So I wouldn't expect the product after its sell by date to last as long in my pantry as a product after its best before date. And I probably wouldn't eat a sauce which was 18 months after its sell-by date. But it's very seldom that you will find a canned or dried good product which has a sell-by date. They tend to have a bit before date. Sell-by date tends to be on chilled foods, on ready-made meals, and is typically used together with a use-by date.
Yes.
Sell-by date on its own is not a food safety indicator as such.
No.
On the other hand, we get to the use-by date, which can also be known as the best consumed before date, the recommended last consumption date, and there are those scary words, expiry date. And the use-by date is probably the closest thing to an expiry date, but in reality, it's still not an expiry date. If one simply read the definition, it says that it means the date which signifies the end of the estimated period under the stated storage conditions after which the product would probably not have the quality attributes normally expected by the consumer, and after which date the food should not be regarded as marketable. You will note nowhere does it say the food would not be regarded as safe. It simply says it would not be regarded as marketable. Perhaps it would smell off, or the color wouldn't be pleasant, or something like that. So it's certainly getting very close to the point where I would not suggest that it's used as a food for humans, but the words used by do not mean that if you eat it the next day you will die. That is not what.
Absolutely.
But certainly, if you're a retailer, you should not be selling a foodstuff after this date, because if you did and a consumer got ill, they would most certainly have a claim against you. Because, as I say, don't sell it after the use-by date.
Yes, absolutely. Now, I had a crazy situation the other day where I tried to buy some meat that was on special from Woolworths. And in this case, it was the sell-by date that had, it was the day of the sell-by date. And their system just would not allow me to actually purchase this perfectly good steak. And I was, in fact, going home that evening to go and cook it. It was for the same day, but I landed up not being able to buy that particular pack purely because the sell-by date was the day of the purchase. And yeah, I kind of walked away from that thinking we're getting a bit confused now with, you know, the use by, because it's I suppose it's because they're often used as synonymous, but it seemed crazy to me when I wanted to buy it and I was going to use it and it was going to go as waste.
Now, I think it's a misinterpretation by that retailer of what the sell-by date means. Now, if they are using it to signify that after that date it should not be eaten, then in fact they're using the wrong wording and they should have used by, not sell. So I think it could be an error on their side.
Okay.
Sure. Moving on to date marking and the prohibitions related to date marking, Regulation 12 in R146 says that no person shall import, manufacture, sell, distribute, or donate, and you need to focus a little bit on this word donate, a foodstuff unless a date marking is clearly indicated on the label or container of such foodstuff, except those foodstuffs which are in Annexure 4, which are products like sugar, vinegar, honey, which are not expected to go off. You know, I mean, let's face it, why did people preserve foodstuff with sugar, like jams and preserved fruit? Because it just doesn't go off in the presence of sugar. But the important thing is that you can't even donate a foodstuff if you've removed the date marking. Any foodstuff, even that which is donated, must have a date marking. It then says the date shall be preceded by the appropriate words, such as best before, use by, or sell by, and you can abbreviate best before with a BB.
Okay.
And then it says, to note the words in red, the date marking may not be removed or altered by any person. And if you look at that television program recently on ETV regarding the raid on the South Bakers warehouse in Bloemfontein, the whole issue there from a legal perspective was that they were in fact removing and altering the dates on the product. Had they simply left the dates on, no criminal offense would have been committed, because you are allowed to sell a foodstuff after its best before date. Perhaps the clients wouldn't want it, but they wouldn't have been committing as criminal offense. The offense comes in when you start erasing and replacing the date with a later date.
Okay.
And that is the criminal offense.
Okay. Now, while we're talking about this, the products that were sort of discussed on that particular television program, can you make a distinction between a product that would be used or sold directly to a consumer, or a product that is sold in bulk to, say, a bakery that we're then going to bake up muffins and then sell the muffins? So the muffin mix is a bulk bag of, I don't know, say 25 kilograms of muffin mix, which is going into an in-store bakery, which will then be baked up, and the muffins will be sold to the consumer. Would it be wrong to change the best before date on that bulk product?
I don't see an exemption anywhere in the date marking
Okay.
provisions in R146.
Yes.
It simply says the date marking may not be removed or altered by any person.
Yes.
So, from that perspective, they don't differentiate between a 25-kilogram bag and a 500-gram bag of muffin mix you might use at home.
Yes.
So from that perspective, I don't think that you can change those dates. There are possible ways of getting around it, and that would be to, for example, provide it in real bulk, accompanied by trade documents rather than the label on the packaging itself.
Okay.
And I suppose then you wouldn't technically be changing the date on the packaging, because you would print the trade documents at the time that you dispense the product. But you need to look into the legalities of that a bit more closely, just to be sure that there aren't other loopholes one is treading on.
Sure. Okay, we'll talk about that some more at the end.
Yeah,
okay.
But I think once a product has a date applied to it, you cannot go and change it.
Okay.
The Foodstuffs Act makes it a criminal offence, in fact, and under the Foodstuffs Act itself, it says any person shall be guilty of an offence if he, I suppose it should be or she, publishes a false or misleading advertisement, or for the purposes of sale, describes any foodstuff in a manner which is false or misleading as regards its origin, nature, etc., etc. So they make it an offence to sell a product in which you've materially misrepresented one of the important issues, one of which, of course, would be the durability dating of the product. And in fact, one can be prosecuted and you could be imprisoned or fined for doing this. I think what's very important to understand is who would be fined or imprisoned. And in every food premises, there is a certificate of acceptability of premises on the wall. And on that certificate, a person's name and ID number appears, and that person is the person responsible, is the responsible person for those premises. He is the person in charge of those premises. And whether he's actually at those premises or not is irrelevant. His name is on the certificate. And that would be the person primarily to be prosecuted. Obviously, if that person was to come up with evidence that he was told to do what he does, then he would be prosecuted together with whoever told him to do what he does. But he wouldn't get away from it by simply saying, it wasn't me, somebody else told me to do it. If you think of a parallel in real life, if you tell somebody to steal a car and they steal the car, they cannot get away from the criminal offense by simply saying, well, they told me to steal the car, so I did it.
Yes, no, absolutely.
Guilty.
Yeah, so it's quite interesting because, I think a lot of people think that certificate of acceptability is just there to make sure that you've got enough hand wash basins and that there's someone responsible for pest control. But when your name's on the paper, your name's on the paper.
Exactly. The person in charge of the premises will be the primary target until he can show that, in fact, he didn't do it. And not only that, he took steps to prevent it from happening. There are systems in place to prevent it from happening. And it was perhaps a rogue employee or something like that. But certainly in the case, for example, of the South Bakels television program, it was clear that the management were very well aware and involved in the changing of the dates.
In the process. So you would say to someone, you could have someone like the food safety person who is told to do this by top management, or they should at least then put in writing that they do not agree with this practice. But if they're sort of threatened or they're, with disciplinary action and they have no choice, there should at least be some documented evidence to indicate that I didn't do this of my own volition. I did this because I was instructed to do so.
No, not at all. No, they must never do it. If they are instructed to do it and they refuse and they get threatened, they should lodge a grievance in terms of labor law. You can't threaten an employee with repercussions for refusing to break the law. So, no, not at all. No. If you agree to do it, there's no such thing as I did it because they told me to. If you did it, you did it.
Okay. Again, that's a very important legal principle that I think people should take note of.
Now, if you did it, you will carry the responsibility. Potentially, you can sink your employer as well, but you're going to go down with them.
Okay, right. So rather lose your job than break the law. That's what you're saying.
Yeah, and then sue them for unfair dismissal, and you can get lots of money and so on. So I would refuse to do it, and then go for a labor grievance, and if necessary, then claim unfair dismissal.
Okay.
And you should have them, by the way.
Yes. Okay, let's continue.
All right. We then come to the Consumer Protection Act, and the Consumer Protection Act says that under Section 24, which deals with trade descriptions, that a person must not knowingly apply to any goods a trade description likely to mislead the consumer as to any matter implied or expressed in that trade description. Now, obviously, if I change the date, I am misleading the consumer in thinking that the product is fresher than it actually is. Section 29 says that a producer, importer, distributor, retailer, or service provider must not market any goods or services in a manner reasonably likely to imply a false or misleading representation concerning those goods, or in a manner that is misleading, fraudulent, or deceptive in any way. Now, obviously, if you change the date and you don't tell somebody you've defrauded them, in respect of the nature, properties, advantages, or uses of the goods. And Section 41 says a very similar thing. So, in terms of the Consumer Protection Act, you could be committing a criminal offense under Section 110, where it says it's an offense for any person to alter, obscure, falsify, remove, or omit a displayed price, labeling, or trade description without authority. Now, the without authority, I think, is a bit possibly misleading, because you can never be authorized to change a date. But certainly it's an offense to change the date. And certainly this is the section that the National Consumer Commission relied on during its raid on South Bakers. Honestly, I'm not sure it's the right section to be relying on, but this is a section that they relied on. And should the company be found guilty under this section, then their maximum fine would be 10% of the total business turnover. Not only 10% of the sale of the specific product, or 10% of the profits, or not even 10% of the turnover of the Bloemfontein regional branch. It would be 10% of the whole company's turnover in South Africa.
Oh my word. So, I mean, that is significant. That is not something that should be taken lightly.
No, and in fact, these types of fines have been imposed by the National Consumer Tribunal, not in this type of situation, but the National Consumer Tribunal is the same tribunal that deals with consumer complaints under the National Credit Act.
Yes.
And in those instances, companies have been fined several hundred millions of rands. And not just one company, there have been several such cases. So it's completely possible that the National Consumer Tribunal could fine a company that is doing this, i.e. tampering with the dates and then selling the products to the public.
Now, I did some very brief research, but and came up with quite a few instances in the last couple of years where there's in fact been not necessarily television coverage, but there's definitely been press coverage of similar instances, and so I'm wondering whether we're going to have a precedent set, because it seems to be on the increase, and there are more and more complaints being raised. So it will be interesting to watch the case.
Well, look, let's face it, it's sensational. It
of course
gets us away from the normal drudgery of politics every day on TV. And of course, it's of interest to the public, because food, everybody eats every day, or tries to anyway, and it affects your health if, for example, they tampered with the date of a product which could harm you. If I think of those products that were on carte blanche recently, which are more likely to harm you than a dry bakery product, which had
absolutely. But it's the principle, and it's the breach of trust, as far as the consumer is concerned, because I'm trusting you to take my health into consideration, and here it would appear that you're deliberately, abusing that trust, and I think everybody gets upset.
Yes, yes. So the Consumer Protection Act also provides for protection for consumers in that they could claim for any harm that they suffered as a result, for example, of eating an expired foodstuff, or whether the date had been tampered with, or they weren't aware what the date was, etc. And Section 61 of the Consumer Protection Act provides for the so-called no-fault liability of the importer, manufacturer, wholesaler, and retailer of unsafe, defective, failed, or hazardous goods. Or very importantly, and I think this really applies to the durability dating issue, where inadequate instructions or warnings have been provided. So a use-by date, in my mind, is a type of warning. It warns the consumer,
Yes.
use the product by the date. So that is a type of warning that you're giving the public. And if your warnings are inadequate, you can in fact be liable. The other issue I wanted to raise was, if you import a product from overseas that is past its use-by date or in some way contravenes the durability dating requirements, the importer would be liable. Nobody in South Africa has to go and sue a supplier overseas. Someone and if you're the importer, you would be liable. If you're the retailer, you would be liable. That's
yes, absolutely. And yes, and I think again, I've been in retail outlets where they are selling imported foods, and it has passed its best before date. And I mean, obviously the price is good, but the fact of the matter remains that just because it's an importer doesn't mean the law doesn't extend to imported products. And like you said, it's actually that retailer that would be found to be at fault.
Sure. So durability dating, as I say, is a type of instruction in or warning. But for example, I don't think best before is a warning. To tell somebody this product is best before tomorrow and they eat it a week later, they weren't warned that the product was going to be off a week later. Sell by date, also not. I think only use by date is a clear warning that a consumer shouldn't eat the product after that date. And if they do, they're doing so at their own risk.
Absolutely.
I eat the product which is a week or two after its best before date and I were to get ill, I would have a claim under the Consumer Protection Act against the importer, wholesaler, retailer, etc., or manufacturer who merely applied a best before date and didn't put a use by date.
Yes, okay. So
a further element of liability which is introduced by the Consumer Protection Act is that of no-fault vicarious liability. Now, vicarious liability sounds like a complex term. It merely means that an employee of a person can be liable together with the employer. If your manager goes and tampers with the dates, then both you and that person would be liable together. You can't turn around and tell a consumer that's now got food poisoning or something, oh, it's not my fault, sue that guy, he changed it. We never told him to change it. As long as he's carrying out the activities on your behalf and you're not properly controlling him, you would be liable. Obviously, if you had proper systems in place and training and procedures, and this person nonetheless went and did this and pocketed the money, so it could be shown that he wasn't doing it for you and on your behalf, then may escape liability and just the employee may be liable.
Yes. Okay. Again, the importance of training records and making sure that you've got those systems in place.
Sure. The one problem that I've seen in the past is that retailers would require a supplier to send their merchandiser to uplift expired stock from their fridges, for example. And the difficulty they have there is that the consumer has gone to the supermarket to buy the product. So they expect the supermarket to be taking all necessary steps to keep the product safe. The fact that they've now got a part-time merchandiser who's works 2 days a week or something, and he has now not looked properly through the products in the chilled refrigerator and hasn't removed all the product after its use-by date, wouldn't be a defense against the claim. The responsibility would still be with the retailer to at least supervise the merchandiser, make sure he's doing his work properly, etc.
That's an interesting one, which I think we could get a lot of comments on, coming from manufacturers in that regard, because the merchandiser is the person who's working on the shelves, but in some cases it almost feels like the retailers don't accept any responsibility, which, as you're saying, is not in fact the correct way of doing it.
Look, I think I think contractually, yes, the retailer can have a contract with the manufacturer that says you are responsible to remove it, but that contract, yes, will hold no water against the consumer, because the consumer doesn't have, yes, to take note of a contract between the manufacturer and the, no, retailer. They weren't shown the contract, they weren't warned about the contract. According to the law, yes, they can expect that the food they buy to be good quality and to be safe.
Absolutely, absolutely. You're saying to the consumer, there is a warning on the packaging, and if the consumer fails to take the warning, then there wouldn't be grounds for a claim on behalf of the consumer, provided the appropriate warning is given, as you said. Now, Janusz, we've had a couple of questions, a couple of specific questions. One I think you have answered, and that was, can I eat a product after its best before date? And we've agreed you can. If I understood you correctly, you would not advise that you eat a product after its use by date, because that would be the closest thing to a safety warning. The other question we had was, can I change the date marking on a bulk product? And the answer to that question is no. If the product is labeled, the product is labeled, and you should not tamper with that date. I think it's possibly we need to talk a little bit about why are we changing the dates? Why is there a need to change the dates? And that I think has more to do with.
If I want to go one step back to the bulk product scenario, because I've been giving it some thought. Look, if the product is still in your own warehouse, it has never gone out into the trade. You manufacture it, you've got it in your warehouse, it gets, yes, past its best before date in your warehouse, never been into the trade, there is a potential that you can actually change the date under those circumstances. Obviously, having taken due care to make sure that the product is still safe and of good quality, otherwise you'll be contravening the Consumer Protection Act.
Yes.
But once the product has been out, yes, into the trade, you cannot retrieve it and then tamper with the date. That would be a criminal.
Of course. Of course, of course. So you could have, I've worked with a company, for example, that had supplied frozen product. And, the frozen product is stored at -40. Really, they were, had extensive freezing capabilities, and they were shipping a lot of product overseas in frozen, refrigerated containers. But some of the varieties were relatively slow moving. So you could have a product that spent more than a year in the fridge, but it was still perfectly acceptable to use. After about 2 years, the quality did start to go off, but there were often instances where they were even requested by customers who might even have had product in their freezers that wasn't moving as quickly, to ask them, can we extend the shelf life? Can you confirm that it would still be safe to use this product even after, its date has, its use by date has expired, or its best before date rather has expired, and it was in fact in this case customers asking them to extend the dates, but I think and the reverse is true. It's been in the freezer, but when we've done tests, the tests show it's still fine, so we can extend the date in that regard. Okay, then one last question would be in relation to this kind of situation happening to a company where there is a raid, and that kind of situation. What kind of evidence should the company have in place? I mean, where should the focus be with regards to systems to try and ensure that they can defend themselves?
There's no defense when you're filmed on television having staff cutting open bags, decanting them into new bags so they can have a new date, having other staff using methylated spirit rags to wipe off dates and printing new dates. I don't think there's any system you could have that can defend you against that. I mean, The system should be there to prevent you from doing those types of things. So really, you need proper procedures and proper training for the people in the field who are in charge of those types of premises, so that they understand what it is they can do, what it is they can't do. Because I honestly believe that what happened in Bloemfontein wasn't because that individual did it maliciously and intentionally. He actually thought he was entitled to do what he was doing. You only have to watch him on television to realize that when they started recording him, he felt perfectly safe and entitled. And he was saying, well, of course I do it. You know, what's wrong with that type of thing? So the first thing is proper training of staff, proper systems in place. Dare I say it, less financial pressure, because I think a lot of these things are happening due to financial pressure. A manager is given a KPI to reduce wastage, whereas the wastage is beyond his control because the contract is in place with the retailer, which says, if we don't sell it, you come and uplift it. The sale is out of his hands. He has no control over whether the retailer sells it or not. But his Christmas bonus depends on reducing wastage.
Absolutely.
So those are the types of things that one has to be very careful when one imposes performance targets, etc., on staff. Yeah, I think that's really probably the most important thing when it comes to this type of situation. If you are going to be selling, sorry, if I may say this, if your business is to sell food after its best before date, which, by the way, I don't believe there's anything wrong with doing that, you must simply make sure that the clients understand very clearly that the foodstuffs they are buying are after their best before date. You don't tamper with the date, you don't take off the date. You put a sign up which says, this food has reached its best before date, and then you use the definition in the regulation, which the public can then read for themselves so they understand that it's not a safety issue, but maybe a slight reduction in quality. And that is how you would approach the sale of best before products. Products after their best before date. The one concern you need to have is that the original manufacturer may want to protect their brand. So they may want to take action against you, not in terms of the fact that you're selling, that you've tampered with the date, but rather that their brand is out there and you're selling a product of which the quality has deteriorated.
Absolutely, yes, that's definitely something to consider. The other thing is regarding reprocessing expired food. So you could have, products that have now gone. It's an ingredient and it's now gone past its best before date and even its use by date. And now I use that in a formulation. For example, I'm going to cook something in a sauce, and I've got one ingredient that is now, for all intents and purposes, no longer fit for consumption. But if I cook it up, you won't know. So why shouldn't I do that?
Until it's left your premises, you manufactured it, it's in your storage, never gone out, and it's still safe for human consumption. In fact, you may reprocess it. Once it's gone out into the trade and it's a perishable product and it comes back, that is covered by a processed foodstuffs regulation under the Department of Agriculture and the Department of Health. And there are very specific restrictions on when you can and when you can't reprocess such a foodstuff. But certainly, if it's a processed foodstuff that's been out, it's past its use by date, I think one can clearly surmise that that product can then not be put as an ingredient into something else.
Not be,
But I think it's important to read that specific regulation for yourselves, depending on what the product is that you would like to reuse as an ingredient.
Yes. And then my last point, Janusz, really has to do with, if I'm formulating a product and I'm trying to determine the shelf life, you could have a product that has, or rather you could have a final product that has a number of ingredients, and each of those have their own use by or best before shelf life. And how should I take that into account when I determine my own shelf life? Should the shortest shelf life determine my shelf life? The longest shelf life determine my shelf life?
No, not at all. I mean, can you imagine if one of your ingredients is milk, and the milk shelf life is 3 days? But now you're putting it into a long life custard. The shelf life of the custard can't be the shelf life of the milk. So the product, the final processed food product shelf life must be determined using scientific methodology as to what its shelf life or durability date will be. It's not simply the shortest of the shelf lives of the ingredients that you use. And the shelf life of the ingredients really doesn't have any bearing on in most processed food cases, on the shelf life of the finished product.
And I think based on what we've been discussing today, there should be more emphasis on determining reasonable shelf lives, so that there is less need to extend or even consider extending these dates, but rather knowing that the date that you have on your product is in fact the date that it will last. And possibly that will mean that some of our best before dates can be extended and can reasonably be extended, because scientifically they are still able to be used. The product's still able to be used.
Food wastage. I recently bought a 2 kilogram sugar at Spar, which had an expiry date on it, had a best before date. Now, if one looks at the regulations, sugar doesn't require a best before date. So, for example, in that instance, by putting on a best before date, a lot of product could end up being wasted, which need not be wasted.
No. And I think there's two scenarios here. The one scenario being, if you are manufacturing a product for a retailer, the retailer would probably be involved in defining the best before date, in which case you can't just change it. That needs to be with mutual agreement and obviously scientific evidence. But if it's my product under my brand and I have got the scientific evidence, then I could extend the best before date before it goes into the trade, but I wouldn't need to discuss that with anyone. It would be my brand and my information.
The durability date or the best before date when it hits the shelves cannot be changed after that point. So up until the point that it enters into the trade, it's the manufacturer's choice what that date should be. Obviously, bearing in mind that it should meet the requirements of the definition of a best before date or expiry date.
Yes. Yes. Okay. Great, Janusz. Thank you so much. I can understand why people get a bit confused with all these dates. I definitely agree with you that it's time to sort of rationalize to one date. You tweeted about that recently. And I think based on what you've said, this situation has again highlighted that the food industry needs to take note, make sure their house is in order, because the consequences are significant and we cannot this kind of crime or this kind of situation should definitely not go unpunished. There should be consequences, if people continue to do this kind of practice.
Correct. But perhaps one last point one should make is that the real test is the food still safe for human consumption, safe and fit for human consumption? All of these dates are indications of certain things, as we discussed in the beginning. None of them indicate that on or after a specific date, the foodstuff is no longer fit for human consumption. So the actual test is the food still safe?
Yes, absolutely. Janusz, thank you so much. It's been great chatting to you yet again. And we look forward to our next webinar, which will be in November. Thank you so much for your time, Janusz. If there are any questions, please feel free to drop us a line. You know by now we've got a forum. If you're attending this webinar and you are not registered on our website, please won't you make sure that you go and register so that you can stay up to date with the notifications for the next webinar that's coming up. And if you have any further questions, like I said, drop us a line and we'll do our best to answer those questions. Have a good day. Thanks very much. Bye.